He was just doing his job, standing on top of a train car, doing routine electrical repairs on an ordinary workday. Then his boot hit a patch of ice nobody had warned him about. That single slip, a fall that took maybe 2 seconds, ended with a jury awarding him over $58 million, making it, at the time, the largest slip-and-fall verdict in United States history. Not because he asked for that much, not because a judge felt sorry for him, because of a very specific legal argument his attorneys made, one that most people have never heard of, and one that applies far more often than you'd think. Today, we're breaking down exactly how a wet floor turns into an 8-figure verdict, and the legal concept at the center of nearly every case like this. Here's what most people get wrong about slip-and-fall lawsuits. They assume these cases are about the fall itself. They are not. Legally, these cases fall under something called premises liability, a body of law built around one core question. Did the property owner know, or should they have reasonably known, about a dangerous condition? And did they fail to fix it or warn people about it in time? That question, not the fall, not the injury, is what determines whether a case is worth thousands of dollars or tens of millions. Today's case involves a rail yard worker named Pablo Cipriani, injured while performing electrical repairs on a train car in Palmdale, California. What happened to him, and more importantly what his legal team proved in court, is a masterclass in how this area of law actually works. Cipriani was working on top of a train car when he slipped on ice that had formed on the surface. What seemed at first like a survivable, relatively minor fall turned into something far more serious, a microfracture in his foot that developed into complex regional pain syndrome, a severe and often permanent neurological condition that left him disabled. This detail matters more than people realize. In personal injury law, the value of a case isn't just about what happened in the moment of the accident. It's about the full, documented, long-term consequence of that moment. A fall that results in a bruise is a very different case, legally, from a fall that results in permanent disability requiring a lifetime of medical care. Here's the actual legal test that determines whether a property owner is liable in cases like this. Did they know about the dangerous condition, or should they have reasonably known about it? And did they fail to act on that knowledge in a reasonable amount of time? This is the entire case, boiled down to one sentence. If ice forms on a surface 5 minutes before someone falls, and there was no realistic way for anyone to have noticed and fixed it, that's a much weaker case. But if a hazard existed for hours, or if there's a documented pattern of similar incidents at the same location, the legal argument becomes dramatically stronger. We see this exact pattern in other major slip-and-fall cases too. In one Nevada case, a woman suffered a skull fracture and permanent neurological damage after slipping in a home improvement store. What made that case so damaging for the property owner wasn't just her injury. It was the discovery that roughly 30 people had been injured in similar incidents across that same retail chain's locations in the same county over 5 years, with 3 incidents at that exact same store. That pattern became the legal proof that the company knew about the risk and failed to fix it. So how does a single fall turn into tens of millions of dollars? Compensation in these cases typically breaks down into a few distinct categories, and understanding them explains almost every large verdict you'll ever read about. There's economic damages, medical bills, both past and projected future treatment, plus lost income if the injury affects someone's ability to work for the rest of their life. For a permanent, career-ending injury, projected lifetime medical costs alone can run into the millions. Then there's non-economic damages, compensation for pain, suffering, and permanent loss of quality of life. This is the category that's harder to calculate and often where the largest numbers come from, especially in cases involving permanent disability or disfigurement. And in some cases, there's punitive damages, money awarded not to compensate the victim, but specifically to punish the property owner and deter similar conduct in the future. Punitive damages typically only apply when a jury finds the property owner's negligence was severe, reckless, or part of a repeated pattern they ignore. Here's a detail that almost never makes headlines but massively affects real outcomes. Most states apply something called comparative fault. If a jury decides the injured person was partly responsible for their own fall, say, they were distracted, or ignored a visible warning sign, the final award gets reduced by that exact percentage. We actually see this in one of the largest slip-and-fall verdicts ever recorded. A jury originally awarded $85 million in a case involving a man who fell through an open manhole. But because of a pretrial agreement related to shared responsibility, that number was ultimately reduced to $18 million. Even massive jury verdicts don't always represent the final number a plaintiff actually receives. Here's the pattern running through every single one of these cases. The size of the verdict was never really about the fall itself. It was about what the evidence proved regarding the property owner's knowledge and conduct. A wet floor by itself isn't a lawsuit. A wet floor that the property owner knew about, failed to warn anyone about, and had already caused similar injuries before, that's a completely different legal situation. The law isn't punishing bad luck. It's punishing preventable negligence that a business chose not to fix. This matters more than you'd think, because premises liability doesn't just apply to giant retail chains. It applies to any property owner, including landlords, small business owners, and even homeowners hosting guests. If you're ever injured on someone else's property, three things matter enormously for any potential claim: how quickly you document the hazard, whether you can show the owner knew or should have known about it, and how thoroughly your injuries and their long-term impact get documented medically. Cases aren't won or lost in the moment of the fall. They are won or lost in the paperwork and evidence that follows it. If you want to actually understand the law behind headlines like this, instead of just the shocking number, subscribe. This channel breaks down a real case just like this every single week. And if you want to see how a completely different area of law turned one man's DNA into the reason a murder case fell apart, I covered that case right here.